this case, the victim, Fabio Sementilli, died without a will. Can you explain the significance of that to us in terms of making certain determinations regarding his assets?
Yes. So for purposes of our analysis, because he didn't have a will that designated where his assets would go upon his death, we used the traditional inheritance rules. So anything that was not already designated with a certain beneficiary went to his spouse upon his death.
Can you give us like an explanation of that? For instance, we know that he made certain designations on various policies that we heard about last week.
For example, he had a retirement plan that he had designated partially to his son from a prior marriage. So in that policy, he had designated only 40% to go to his spouse. And so in death, that went 40% to Monica. But in a dissolution scenario and in our ultimate analysis, she would actually receive 50% of that.
Okay. So, for instance, we know that he also had Sun Life Financial, a registered retirement savings plan, in that particular policy where he designated 75% to his wife and 25% to his son from his prior marriage. Without any, for assets with no specific designation, that means that you would have to make determinations regarding how the assets would be distributed according to California inheritance law?
Correct. That would just go 100% to his spouse.
Okay. That would be any community property, correct?
Correct.
So given that there was no premarital agreement between the defendant and the victim in this case, Fabio Sementilli, what's the significance of that as we're talking about community property?
Well, parties use premarital agreements or sometimes postmarital agreements to designate how their community income, how their wages, how their property is going to be acquired during marriage. They can designate that.
You mean they can designate it on whether or not it's going to be community property or separate property?
That's correct.
Okay.
But since they didn't have any kind of agreement like that, the California community property presumptions apply.
So that goes through the California Family Law Code?
Correct. There's family law code that applies, and therefore anything acquired during marriage is presumptively community property, with a few exceptions, gift, inheritance, and then anything that is acquired post-separation is separate property with very few exceptions.
Okay. What is the definition of community property?
It is an asset that's owned equally by both parties.
So 50-50.
Correct.
All right. And what is separate property?
It's an asset that is owned by one party and the other spouse has no equity interest in that asset. There could possibly be an equitable interest, but that's not applicable here, so it's probably not worth talking about.
Okay. Based on your review of all of the documents in both of your indices, did you create some sort of a chart in order to summarize the data?
Yes, I did.
I have a chart, and on the second page it looks like there are some footnotes. May it be marked as people's 126?
Yes.
Showing you Exhibit 126 is Is this a chart that you created in order to discuss or to review various assets in this case?
This is the chart I created to compare the difference in our conclusions and then ultimately my conclusion as to the financial benefit between the two scenarios.
So did you do a breakdown of all of the estate assets, family home, the victim's assets, life insurance proceeds, and any retirement or defined benefit plan?
Yes, this is the entire estate. So you can see there's letters across the top. The A column is each of the assets in the estate that we could verify, and those amounts are then classified by amount in a divorce scenario and in a death scenario.
Okay. So in terms of making this chart, creating this chart, did you also perform some calculations to determine the difference between what the defendant would have gotten in a divorce situation versus if her husband died because he was murdered?
I did. That's column F on the far right side. That's delta between, or the difference between a divorce scenario and a death scenario.
Okay. And did you make certain assumptions in this case in these calculations, divorce versus death?
Yes, I did.
And what type of assumptions did you make?
So the first assumption is for the divorce scenario, I assumed that the date of death was also the date of separation.
Okay.
So anything after that date would be separate property of each of the parties. Secondarily, I assumed that for the death, I assumed that Ms. Sementilli would not be found responsible for Mr. Sementilli's death.
So in other words, if she were to be found not guilty, what she would be able to still inherit?
That's correct.
Or if she had not been caught in the first place?
That's
Sustained.
Okay. Did you make any determinations or any assumptions regarding the home?
yes, I did. So on line 6 through 8, you can see that's the amounts related to the house, and the house was sold, and so in the death scenario we have 337,951 at line 9, and in the divorce scenario we have the 218,350, and that relates to it being 50%, because in a divorce scenario Ms. Sementilli would receive half, whereas in the death scenario she receives 100%. However, I didn't include costs of sale here. I didn't assume that the house was sold. I assumed that she would be bought out of the house, and by doing that it actually decreases the amount that is on line 27, the bottom line conclusion, because it increases the amount that would have been in the divorce column. So
if you were, in other words, the assumption is that the house would not be sold in a divorce situation, that the defendant would be bought out, and therefore you're saving closing costs.
that's correct. So it gives Ms. Sementilli more funds in the divorce scenario, so the difference is less, which makes the amount on line 27 to be less. So it's an assumption that is in Ms. Sementilli's favor.
Okay. In other words, making the amount, the difference between divorce versus death, a lesser amount.
Correct.
Did you make other assumptions in the defendant's favor that decreased your conclusion or your bottom line number, which we see, as you said, in line 27 of $1.5 million? difference?
Yes.
And what were those?
There were certain amounts that we excluded from the death scenario because we didn't have the source documents to show where they came from. For example, there was 2 amounts that came from Procter & Gamble. One was a distribution. The other was an amount that was held in an account that were noted, one in a trust accounting from Mr. Rubin, one in a filing that we know the funds were received, we know the funds were there, but we couldn't identify the source. And so I excluded those from the calculation, and they would have increased line 27. The third was a computer share account that, again, would have increased the amount, but again, I didn't have the source document to show where it comes from. Those 3 together were approximately $120,000.
You mentioned one of them being P&G Distributions. That was per the estate accounting, right? Correct?
That's correct.
Somewhere in the neighborhood of $102,000.
That's right. That was the first one.
A computer share account that was somewhere around $7,700.
Right. It was not a large amount.
Okay. And then P&G stock that was at in a Wells Fargo account.
A Wells Fargo investment account.
Okay. And that was somewhere around $12,500.
Correct. So combined, the 3 were approximately $120,000.
Okay. And all of these were documented in the documentation that you received from the administrators who were appointed by a civil court to handle Fabio Sementilli's estate.
That's correct. But we did not have documentation from Procter & Gamble to identify where they came from or why they were paid. So I couldn't characterize them, and therefore I excluded them from the analysis.
Now, at the time of his death, the victim in this case, Fabio Sementilli, was also receiving various employee benefits that were subject to vesting. What did you do with that?
So for those benefits, to the extent they vest over time, any amount that is earned after date of separation, which again in this case is the same as the date of death, those amounts would have been his separate property. So the longer period we use for the vesting, the more that is separate property.
Okay.
So what we did is assume the shortest possible vesting period. For example, there's one, it's a small amount, it's $4,000, but we assumed that it was 100% vested, so it was all community property. The larger P&G equity award, we assumed only 3 years, so that it was more community property. So again, it was an assumption that was ultimately gave us a conclusion that was more beneficial, gave more funds to Ms. Sementilli in the divorce scenario, thereby reducing the delta and lowering the amount on line 27. There's still a difference, but it is a lower difference than it could have been had we used a more traditional 4 or 5 year vesting period.
Okay. So you made multiple assumptions in order to make the distinction between what the defendant would receive in a divorce versus upon her husband's death due to his murder to her benefit.
Right, but these are assumptions that have to be made when we're doing the analysis because we don't have perfect information. So it's just in order to have an analysis that is the most conservative, we made the assumptions that benefited Ms. Sementilli.
All right. And when we talk about, you mentioned approximately $4,000, the Cody RSUs, that's what we see on line 12, correct?
That's correct.
So you made the assumption that it would all be community property invested at the time of death.
That's correct.
And in terms of the P&G stock options, that's what we see on line 16, correct?
That's correct.
That came to approximately $935,814.
Yes, that's right.
All right. What about Fabio Sementilli's P&G pension? I see that on line 18.
Okay, so again, this is a benefit that upon death vests immediately and still is paid out over a period of time. Ms. Sementilli is given 3 options on how to get it paid out. Each option is gives a different amount in total that she could receive. In order to calculate the amount at line 27, I chose the amount that is the lowest possible amount that she would receive. Therefore, the amount that you see at line 18, the $42,682, is, of the 3 options, the least possible amount that could have been there, which creates the lowest amount that falls to line 27.
Okay. Again, so making the difference between divorce versus death a lower amount.
That's correct.
That was assuming a cash payout.
That's right. It's a lump sum payment.
Okay. Now, were you able to make some determinations, again, from the documentation from the estate on the civil side as to any cash at the date of Fabio Sementilli's death?
Yes, from the bank accounts we could see that the 2 accounts, or the total of their personal accounts is on line 2 at $53,563. And the total of the LGI consulting accounts is $9,464. And that totals in column A.
So, for instance, how would that work out in divorce versus death? So we can see how this chart works.
So in column C, you can see, or B and C, in column B, you can see that 50%. And C is 50% of the amounts in column A. Right. And then in column D, you see 100%, and again, 100% of the amount in column A. Because in a divorce situation, it's divide by 2 in California from a community property standpoint. That's correct. And from at the time of his death, there were no designations on the account any other way, and the accounts were joint accounts, except for actually the LGI account was in Ms. Sementilli's name. So only. At least from the statements, that's how it appears. So those accounts went 100% to her upon death.
Okay.
And even though the account is only in Ms. Sementilli's name, even in divorce, she would still only receive half of it, because unless she could somehow trace it to trace the funds that were in there to a separate property source, which I assumed could not be done since LGI was not formed before marriage.
Okay. And so the difference there between what she would get on divorce versus death, we can see that it's a difference of $31,513, basically 50%.
That's correct.
If we had the situation that we do have in front of us where the victim's dead, she gets the full amount of $63,000.
if she's not found responsible.
Yes, that was an assumption we already talked about that you made at the beginning.
That's correct. I can no longer see the line
Oh.
items, but I have a copy in my binder. Is it okay if I look at that one?
Sure, I just wanted to put it on the screen to make sure that where you can see it, I can back out a little bit. There we go. All right, let's talk about the family residence at 5012 Queen Victoria Road. We see that on lines 5 through 8 on your chart. Can you walk us through that?
Yes. So line 5 is just the title. It's just the address. So
Right.
line 6 is the total amount, and that's the total amount it was sold for. The line 7 is the mortgage at the time of Fabio's death, and then the net cost of sale. So line 9 is the net proceeds. And in fact, I think actually line 7, I could look at my source document, but line 7 is likely the mortgage at the time of the ultimate sale.
Okay. So the home was sold for $1.350. Yes?
Yes,
And they owed a mortgage on the house of $913,300.
that's correct.
Plus there were costs of the sale, as we talked about previously, of $98,750.
749.
Yes. And so how does it work? If there were to be a divorce, this would be characterized as community property?
That's right.
And so therefore each spouse would get 50%.
That's correct. Typically, one spouse buys out the other. It's very common where one spouse stays and then buys out the other, and the other spouse buys a different residence.
And in this particular case, the defendant already received 50%, correct?
That's my understanding of the sales proceeds.
Okay. However, if she were to be found not guilty, then she'll also wind up getting the other half from Fabio's estate. She'll get the full amount, correct?
That's my understanding.
I'm going to object, Your Honor. That's her understanding. No foundation.
So rule.
So on in death, we're talking about an amount of $337,951.
Correct.
And so the difference between what she would get in divorce versus what she would get if Fabio was dead is approximately $119,600.
That's right.
All right. Now let's look down the column starting on line 10 where it says other assets. Let's look at what you have beneath that. Can you walk us through? The first one we see on line 11 is a 401k that was being managed through Charles Schwab as of December 31st of 2018.
Yes. So that was the, as it says, Cody 401k, and the amount was $30,492. In a divorce situation, Ms. Sementilli would have received 50%. That's the $15,246. Because Mr. Sementilli passed away, she will receive or would receive $30,492. So the difference is the 50%, $15,246.
Okay. And let's look at the next line, line 12. He had some Cody restricted stock units.
That's correct. Same situation. This is the $4,000 that we talked about earlier. It's $3,995. We assumed that they were 100% vested at the time of either divorce or death. And so 50% would be received if in a divorce situation, 100% is received upon death.
For, again, a difference between the divorce versus death of $1,998, approximately $2,000. right?
Correct.
A $2,000 benefit by Fabio dying.
Right.
Okay. And then there was a car loan, and I see here you saw that was written off, so that came to a net total of 0 on both sides.
That's right.
Okay. And then there was accrued vacation that was paid out, which we heard about last week, of an amount of $5,689, which appears on line 14 of your chart.
Yes.
How does that work?
So accrued vacation is not a divisible asset in divorce. It's usually used by the party unless there's some extraordinary circumstance. So an amount of 50 hours would not have been divided. But in the event of death, the company paid it out just like they would if he had left the company. So that $5,689 is the difference.
So that was, again, a benefit to the defendant by the death of her husband of $5,689.
That's right.
All right. Let's move down to line 15. You have P&G profit sharing, PST.
Yes.
Tell us what we see here, please.
Again, that's a profit sharing plan that had $43,677 in it, and half of it would have gone to Miss Sementilli in a divorce situation, or $21,838, whereas in a death scenario, Miss Sementilli receives $43,677, for the difference being the other 50% of $21,838.
Okay. And again, this was an amount that, just like the vacation, was paid out and transferred to the defendant in March of 2017. So she benefited by almost $22,000 through the death of her husband on this one.
That's correct.
All right. Let's look at the next one, which looks like it's one of the largest numbers, the P&G stock options, which was valued at $935,814. How does that work?
These are the stock options that we talked about a little bit earlier. So part of this is separate property, because after separation, the portion that vests is allocated to Mr. Sementilli in a divorce situation. So we did do that time rule calculation, and $140,102 is carved off completely for Mr. Sementilli, but $795,712 is community property. So 50% of that amount is the $397,856 that Miss Sementilli would receive in a divorce situation. So it's 50% of the $795. Whereas
Because it's half of the community property portion?
one half of the community property portion. Whereas upon death, she not only receives 100% of the community property portion, she also receives the $140,000 of his separate property.
So in other words, by his death, she winds up getting the full $935,814.
That's correct. So this one is actually the biggest delta. So it's $537,958 that is the benefit for the Procter & Gamble stock options.
Okay. And then also we heard last week about a P&G ISOP, the International Stock Ownership Plan, that we see on line 17.
Yes.
And tell us about those figures based on the documentation you reviewed from the estate.
This one is one where Mr. Sementilli had done a beneficiary designation when he signed up for the program, and he had designated only 40% to go to Miss Sementilli. So upon his death, that's the portion that she would receive, whereas in a divorce, she would receive 50%. And so this is one where she actually receives more in a divorce situation than she would in a death situation. So it's a negative of $3,988.
Okay.
So,
And then beneath that, you have the P&G pension plan. And you talked earlier on line 18 about there being different choices, whether she took a lump sum or a monthly amount. What was the documentation with respect to his P&G, Fabio's P&G defined benefit plan?
this was
Sorry, core pension plan.
the core pension plan. We received documentation from the company that outlined a lump sum payment and then two options for payments over time, beginning at different time periods. So, beginning in, I could look at the documents if you'd like, but I think beginning in 10 years and beginning in 20 years and going for a certain number of years into the future. And then depending on if you waited the longest period, you actually got it for a longer period of time or a bigger amount, and so it ends up being a larger dollar figure.
Okay.
But we assumed the one that actually came to the lowest dollar figure, and that's receiving it now, a lump sum cash payment of $42,682, and that is 50% at divorce or 100% upon his death.
Okay. So that's a difference of somewhere around $21,000 to her benefit, using the lower number, the more conservative number, once Fabio died. She gets 100% of it.
That's correct.
All right. And then there's a Wella Canadian pension plan on line 19. Tell us about that.
Yes, that's a very small pension plan, $5,000, and again, 50% if there's a divorce and 100% if Mr. Sementilli dies.
Okay. So the benefit to her, again, is the difference is approximately $2,500.
That's right.
Okay. Then we see that he had two accounts through Sun Life Financial, one being a registered retirement savings plan and one being a non-registered. Let's start with the one that's registered on line 20. How does that work?
Again, this is another one that when Mr. Sementilli signed up, he designated the beneficiaries. And so for that one, upon his death, Ms. Sementilli was designated to receive 75% of the funds in that account. So she was to receive $11,700 upon his death, whereas in divorce, she would receive 50%, and that is the $7,800.
This is the one that we talked about earlier, where Fabio had designated 75% to his wife and 25% to his son Luigi, correct?
That's correct.
Okay. So this one is a difference again of $3,900 benefit by his death versus going through a divorce.
That's correct.
All right, let's look at line 20. It looks like line 21, the non-registered retirement savings account through Sun Life. Looks like a very small amount.
Yes, it's a very small amount, $134, and again, it's the 50% versus 100%.
And there was no beneficiary designated, so the full amount would then be payable to the defendant on his death.
That's correct.
All right. So if we look at a total of all of the other assets on line 22, from what is in the estate, $1.135,461,000. 50% of all of that in a divorce would be $499,335.
Just to make sure the record's clear, the first number is $1,135,461.
Yes.
And yes, the portion that is divorce is $499,335.
However, upon his death, the benefit to the defendant is $1,105,895, correct?
Yes.
So when we go over to the difference in the far right column, it benefits her by over $600,000. Is that right?
That's correct. $606,560.
Now let's look at the life insurance proceeds on line 24. Tell us about how this gets handled.
We cannot see that.
Thank you.
The life insurance proceeds are only the life insurance proceeds that are payable to Miss Sementilli. These don't include the life insurance proceeds that were payable to any other party. And obviously in divorce, none of these are payable to Miss Sementilli because these are all term life policies. If they had been whole life policies that had cash surrender value, that would not be the case, but they did not have whole life policies.
So therefore, it's zero on in a divorce scenario or the full amount on death.
That's correct. And these, I think, primarily related to employment policies.
So in this case, again, we're only looking at the portion of the life insurance that was designated by the victim for his wife. She gets the full 100% of it, which is $720,067.
That's correct.
So the difference is that amount.
That's right, because there's nothing payable upon divorce.
Right. And then on line 25, you have something called post-death separation compensation. What is that?
The company elected to continue to pay Mr. Sementilli for 6 months after he passed, and so that compensation, this is the net that was received after tax, that amounted to $50,271, but in a divorce situation, that would be his separate property. So none of that would be divided with Miss Sementilli.
So the full, again, just like the life insurance, it's either nothing or the full amount of $50,271.
That's correct.
Okay. And what was the salary amount? Gross?
I would have to look. I have his. He was receiving, I think, $280,000 is what I was using for other calculations.
Okay. That would be his salary plus some other...
Plus the other compensation.
And again, as you mentioned, this is compensation net, so it's post after taxes are removed, correct?
That's correct.
All right. And then there was also some debt from the credit cards that we see on line 26.
That's right. The parties had credit card debt. So in a dissolution, Ms. Sementilli would have been responsible for half of it. But when Mr. Sementilli passed, she became responsible for all of it.
Okay. So just as in one of the other situations we talked about, I think it was the closing costs on a sale of the property, the entire debt, you subtracted that from the amount that she stood to gain by her husband's death, correct?
That's correct.
From the total that we see over in column F.
Yes, that's correct.
Okay. And so the total difference between, if we look at line 27, the estate being worth $2,262,915, in a divorce situation, she would be looking to inherit approximately $727,000, correct?
She would receive.
Not inherit. She would get, because he hasn't died in a divorce, correct?
That's correct. That's the amount that we could verify.
Okay. And in death, she stands to inherit, assuming she's not found guilty, $2,233,349.
That's correct.
So the difference, again, between what she stands to inherit versus what she would have gotten under a divorce scenario is approximately $1.5 million.
That's correct.